So good evening, everyone. We're starting here promptly at 6 o'clock, just because we have a lot to cover tonight. I want to welcome you all to SALT Talks. My name is Patty Schramm. I'm the parent trainer resource coordinator for the SALT Talks program. Tonight we've been, the month of February, we've been talking about what happens when I'm gone, or how do I plan for when I'm gone. So we've been talking about guardianship and different topics surrounding that theme throughout the month. So we're ending our month. We have the Montgomery County Probate Court here with us. We have Joe Gallaghar, who is the Chief Magistrate with the Montgomery County Probate Court. And we have just off screen there, we have Mr. William Bailey. He's the Court Investigator, and he's going to give you that side of the information as well. So, and just if you have questions, I do see we have one out there, and we'll get to that here in a minute. But if you have questions, go ahead and type them in as the presentation's going on. Go ahead and type them in the chat box. And then maybe following the presentation, if you're not comfortable with the chat box, when we stop the recording, we can open it up for a full discussion if you're more comfortable with that. But feel free to ask your questions in the chat box as the presentation goes on. And since we are recording the session, I think mostly everybody has their video off, but if you can make sure you're muted or your video off just for your privacy. So I'm going to turn it over to Mr. Joseph Gallaghar with the Montgomery Probate Court. Thank you for being here tonight. I have you as co-host, so you can share your screen whenever you're ready.
Thank you very much. My name is Joe Gallaghar, and I'm a chief magistrate with the Montgomery County Probate Court. I've been an employee of the court. This will be my 23rd year at Montgomery County. So I wanted to go at the beginning and sort of go through what the items I'm going to be talking about tonight. There's a lot of items, and and it goes like this. What is guardianship? How is the guardianship different from POAs and conservatorships? What is the idea of least or lesser restrictive means? I wanted to talk about that. I wanted to review the documents that are required in our court before a guardianship is filed, or what you have to produce in order to get a guardianship filed. I wanted to review the BCI report idea on how you obtain a background check, which is required in the applications. You also, we're going to review how the documents get filed, because we are a court that e-files, electronically files their documents, and I wanted to sort of walk through that a little bit with you, and sort of touch on the question if you need an attorney to file the documents, and also a new development in our court system, at least in our court, is the creation by Judge Brannon of the Probate Resource Center, which is about 2 months old. And it is an opportunity to get some help with legal questions and document preparation. So I want to talk about that for a while. I want to talk to you about what happens after you file the guardianship application, sort of the lead up to the hearing. I'm going to talk with Mr. William Bailey, who is one of the investigators for the court, about what he does when he comes out to serve the prospective ward with the guardianship application or notice of the guardianship application, and what he observes and how he interacts with the court to give us information, because he is really the first person to sort of meet the guardian and also usually meet the ward. Then I wanted to talk about what happens at the hearing, how we go through that process, and what just a normal guardianship hearing is like, and how long it is, and things like that, and who has to attend. And then I wanted to just touch lightly on the obligations of a guardian, both guardian of the person and guardian of the estate. And particularly in light of the fairly recent rule, Supreme Court rules, which are the Supervisory Rule 66, which revolutionized the way probate courts in Ohio were dealing with guardianships and how they took on more responsibility, and talk to you about that. And then what I wanted to touch on how the probate court wants to remain in touch with the guardians and the wards. And also, finally, I wanted to touch on the issue of what is a guardianship complaint and how are they processed. So we have a lot to do, so I'll get started. I don't know how much everyone knows about guardianship, but I did want to go through some of the ideas at the beginning. So what is a guardianship? Well, guardianship is a legal court-ordered situation where, hang on one second. Sorry. Well, a guardian is any person, association, or corporation appointed by the probate court to have the care and management of a person, the estate, or both of an incompetent or a minor. So in this situation, we're going to talk about guardianships of adults. A ward is any adult person found by the probate division of the Court of Common Pleas to be an incompetent person for whom a guardianship is established. And so you have to ask, well, what does that mean? What does incompetent mean? And under Ohio Revised Code, section 2111.01D, an incompetent person is when a person is mentally impaired as a result of mental or physical illness, disability, or as a result of chronic substance abuse, so that he or she is not capable of taking proper care of his or herself or property. So I know there are a variety of different guardianships. There's the guardianship of the person only, a guardianship of the estate, which means a guardian of the person's money. There's the combination guardian of the person and estate. There are situations where there are emergency guardianships and limited guardianships. So I wanted to sort of talk about the difference between POAs, powers of attorney, which I'm sure you all heard about, and conservatorships, as opposed to guardianships. And the chief difference is that a power of attorney is a voluntary act on where a person allows another person to handle either their healthcare decisions or help them make healthcare decisions, or handle their personal finances. So you can have a power of attorney for the purposes of business or financial matters, or you can have a power of attorney for healthcare. But that's a voluntary thing. That's where the person is not incompetent and they make this decision to allow another person to act on their behalf or for them. A conservatorship is, again, a voluntary situation where the person comes to court and formalizes his or her request to have another person handle their business or financial matters. The person making the request, the person that's filing the conservatorship, is mentally competent and is not incompetent, but is often in a situation where they're physically incompetent or have physical difficulties that make it difficult for them to handle their own business affairs. So that's a situation that's court supervised. We appoint a conservator. There's a hearing. We go through the formalities. It's very much like a guardianship hearing, but it's different in the sense that it's entirely voluntary and created by the person who asks the conservatorship to be created. And the other difference is in both the POAs, or the powers of attorney, and in the conservatorship, they can be terminated at will by the person who signed the original POA or asked the court to create a conservatorship. So those are voluntary. The thing with the guardianship, it has court intervention and it is not voluntary. The court has to find by clear and convincing evidence that the person that a guardianship is necessary. In addition, the court has to determine that the guardianship is the least restrictive alternative. And what do I mean by that? Well, if the person is incompetent, is there a lesser way that we can not put the person under guardianship? And there might be, like, for example, if the person's incompetent, but all that's needed is a payee to deal with Social Security or things like that, then you may not need a guardianship because those could be handled outside of the need for a guardianship. But we have to explore lesser we have to look at all less restrictive alternatives before the court can create the guardianship. And this is a requirement that was set out in Rule 66 by the Ohio Supreme Court. So that's the difference between a guardianship and powers of attorney and conservatorship. So I wanted to go through with you what documents are required by our court. This is Montgomery County Probate Court. And they are, you need an application for appointment of guardian of an alleged incompetent. And that would be the application, which is form 15.0 on our web page. I'm sorry, yeah, 15.0. And it also includes a next of kin, which is a listing of the prospective wards next of kin, and information on how to complete the service. So if we take a look at the application, it represents that the applicant says that the person resides in Montgomery County, and it gives their address and the reason that the ward is incompetent. And they have to fill that out. You list the birth date, you list the next of kin. If you are filing an application to become guardian of the estate, you would post a bond, which you list on the application. You check the type of guardianship you're seeking, which is a guardianship of the estate, person in estate, limited and non-limited. And most often the guardianship is requested would be for of an adult would be indefinite, but if it were a minor, it would be indefinite up to a point when the person becomes 18. And then on the back of the form, it asks the relationship of the applicant to the alleged incompetent. You make a statement that the applicant has not been charged or convicted with a crime involving theft, physical violence, or sexual violence, alcohol, or substance abuse. And if there is an issue, then you have to put what the issue is. And then you would sign that and submit it. The next of kin form is that would list the person's spouse if they're married. It would list, if they're not married, it would then list their children and the lineal descendants of deceased children. So that's what you would list on the 1.0, and the name and address of all those people. And then the service information provides the court with an idea of where the person is to be served. You also need the following documents. You have to create and sign and then file an oath of the guardian. And I can touch on that. And that is, if you become guardian of the person, you promise that you will file timely and accurate reports. You will at all times protect the ward's interest and make all decisions based on the ward's best interest. And you also promise to obey all the orders of the court. If you file for estate, you promise to file a true inventory, which is a listing of the person's property, and report all assets belong to the ward. You promise to file timely and accurate accounts, which are done on a yearly basis. And you promise that you will apply to the court before making any expenditures and get the court's approval prior to doing so. So that's the oath that you would sign. Then you submit a judgment entry setting the hearing, and the court would set that hearing date for you. You can also, if you're a sister or a brother and someone's applying to become guardian of a parent, you can sign a waiver allowing that person or consenting to the appointment of that person. That could be filed. There's also a fiduciary's acceptance, which again breaks down between guardians of the person and guardians of the estate, which are similar to the oath. As I mentioned before, if you are applying to become guardian of the estate, you have to post a bond, which is basically an insurance policy, promising that if there's any issue with money, if you've misspent or have not been not requested the court's permission to make an expenditure, it's possible that they would turn to the insurance, the bonding company, to pay back into the estate that money. And that you can obtain through insurance companies, and that has to be posted. And then one of the really important documents is the statement of expert evaluation, which is for an original or initial application has to be completed by only 3 types of persons. It has to be signed either by a licensed physician or a licensed clinical psychologist. And I'm sorry, a licensed physician or a licensed clinical psychologist. And you would take this statement in, and the doctor or the clinical psychologist would fill it out for you. And it would list his or her name and title, profession, business address, place of evaluation, the amount of time that the evaluator spent, the length of time an individual has been under the care of that particular physician or clinician. And then it asks, is the individual mentally impaired? And usually the doctor will sign yes or check yes. And then it asks, what is the impairment? And then it asks, during the examination, did you notice any impairment of the individual's orientation, speech, motor behavior, thought process, affect, memory, concentration and comprehension, and judgment? And then it goes on to ask, do you believe the condition is stabilized? Is it reversible? And should a guardianship be established? And the doctor or the clinician would have to complete all that, along with any other additional information they want to provide, and sign it. And that needs to be filed with the court. You also need to sign a guardian's receipt, which says that you have received the Ohio Guardianship Guide and the Montgomery County Probate Court's Guardian Handbook, which is available when you file. And then also you would file an applicant's report. Now, the applicant's report is becoming more and more important in light of Rule 66, because this is prepared by the person asking to become the guardian. It talks about what the ward's functional abilities are, bathing, grooming, dressing, etc. It talks about the ward's potential ward's habits. It talks about the potential ward's living conditions. It also asks about if the ward has important documents and where they are. The court is looking for if there's a living will, or if there's a healthcare power or a financial power of attorney. Again, we're looking to see if this is really if the guardianship is the least restrictive alternative. We're also asking the potential guardian to locate the potential ward's last will and testament. So that's a very important document. and if there's any powers of attorney, as I mentioned before. And then there's additional information if there's any allegations of abuse or alcohol dependence or aggressive behavior or unresolved family conflicts involving the proposed wards. And they're asking, why are you applying for guardianship? Which I think is a good question. And as I said, in light of some of the rules, understanding of Rule 66, we're also looking for things like what sort of visitation would be advisable for the guardian to allow. I mean, what people are going to be able to visit with the ward and how often, and if there's a person that should be sort of excluded from visitation. Some of that information could be put down here to give the court advance notice of some problems that may arise and certain limitations that we would have to put on visitation. Also, the religious preferences of the ward and their religious habits are also something that the court is now interested in, because we have an obligation to sort of support the ward's choices in those matters and how the guardian is going to impact those things. Then one of the newer forms is Form 66.05, which is an affidavit that states that there are no outstanding misdemeanor or felony cases against the prospective guardian. So that needs to be signed. And then you can also provide the court with a recommendation of successor guardian. So if you're applying to be guardian and you want, you may be able to nominate someone else to become the successor guardian, and that would be considered by the court. It's not mandatory for the court to appoint that person, but it is a recommendation, and it gives the court guidance in the case where the original guardian can no longer serve or it declines to serve. So those are some of the opening documents. So how do these, I wanted to talk about one of the services. So people ask, do I have to have an attorney to file the documents? The answer is no. If you are a pro se person, if you're operating on your own without help from an attorney, you can come down to the probate court on the second floor of the Montgomery County Courthouse and present your documents. We ask you, if you can, to have those documents reviewed by a new development in our court, which is the Probate Resource Center. This was an initiative by Judge Brannon and the Montgomery County Public Defender's Office. So in other words, the public defender wanted to assist the probate court. The employee, who is an attorney, her name is Gail Miller, is not an employee of the probate court, which would probably be unethical, but is an employee of the Montgomery County Public Defender. And so we have provided her an office. It's on the same floor as the court. It's very close to the clerk's filing area. And I can give you the phone number for that. Her number is 937-496-6729. And what they're asking is that if you want to make an appointment, that you give her a call or email her. Her email is capital CALENDY.com/probate PRC. And the court has found this to be very helpful. Because she's able to go through your documents, make sure you have all of them, help you with getting them correct. And then once she signs off on it, it then gets filed and is then sent through the court system from the clerk's side to the magistrates, and the magistrates then review them one more time and then set it for hearing. If you don't have time or you think your documents are correct, we ask you to come and present them to the magistrate's office. And if that's the case, then the magistrate would take the time to review it and again, either return them with requested changes or tell you to go file them at the clerk's office, and then they would be filed electronically by the clerk. So that's sort of the process. When an attorney files a guardianship application, he has to file it from his office. It comes into the clerk's office electronically. It gets sent to the magistrate for review, and then we deal with it that way.
This is Patty. I'm sorry, can you repeat that email again for me?
Yes.
I'm trying to type it in the chat box here.
Okay. It's CAL
Uh-huh.
EN
Mm-hmm.
DLY dot COM
Mm-hmm.
/PROBATE PRC.
Okay.
And
That was for Gail Miller, you said?
That's Attorney Gail Miller.
Okay, thank you.
Sure. And we have had, we feel this is a really good program. It's helped speed up the process for people. It's less frustrating, I think, when you have somebody give you some very good advice about how to get them in, and then they tend to go through much easier that way. So that's a little bit about sort of the setup. I'd like now to introduce my co-host for the evening, Mr. William Bailey. And Mr. Bailey, why don't you introduce yourself and your background?
Hi, I'm William Bailey. Good evening. I've been an investigator here for a little over a year now. My background is that I'm a retired police officer, and I've also worked with Premier Health as a coordinator and curriculum advisor. So what that's pretty much my background right there. I am assigned to Magistrate Gallaghar to work his cases, and that's really about it.
So I was wondering if you could tell people a case gets filed, what happens at that point for you? How do you get notified about the case being filed?
Once I'm notified through our computer system, which is in our queues, I assign the case to myself, and then we have a certain amount of time to be able to go out and serve the notice of the hearing. We need to have that in 7 days before the hearing. We try to do that well before then. But once we go out to serve the ward, some of the things that we do, I always carry a cheat sheet with me, but we ask them when we go out, if they're in a nursing facility or if they're in a home, whoever we're contacting, we make sure that we get their information, their name and who they are and their title. We also give them a copy of the hearing date. And then for every ward, whether they can understand what we're talking about or not, we make sure that we read them their rights and let them know that they have a right to an attorney, that they have a right to attend the hearing. And then we also ask them if they want to attend. So if they don't want to attend, we just put that in our paperwork. If they do want to attend, then immediately we contact the magistrate and his assistant to make sure that we're going to get them to the hearing, their lawyer is going to get them to the hearing, or maybe a family member is going to get them to a hearing. After that, we start checking out their mental status. We check out the environment that they're living in, whether it be a nursing facility or a home. When I come back and do my investigations, I make sure that I try to list the conditions of the home. If the conditions of the home is, even the nursing facility is not of good standards, I let the magistrate know. If we have to call out APS, Adult Protection Services, or someone like that, then we do that. In talking with the ward or talking with someone who is taking care of the ward, we want to make sure that that person is we want to know if that person is eating, sleeping, okay, or not eating, sleeping, what their habits are. That I think that helps the magistrate to determine some things, because sometimes people are saying that they're okay if they're able to speak, but they're not really eating. You could see it, they're anorexic or something like that. So we make sure that we list that. We also and their mental status. We also try to see what kind of activities they are doing. Some of them are bedridden, but some of them are functional, where they're going to different facilities, or what they call day facilities, where they're going out and they're doing activities in the community or at a center. So we list that. If they're not doing that, maybe sometimes they just like to watch television, or they like to knit, or they like to just draw or doodle or do puzzles. So we let the magistrate know all kind of activities and hobbies that they do.
What do you do with like young adults who are still in high school or still going to school?
Yeah, when they're still going to school, when we go out to serve them, sometimes either we'll go out to the school to serve them, and we'll also talk to the teacher or principals. A lot of times what we're doing here is we're just waiting on them to get out of school, and we schedule an appointment. Most of the time when we go out, we don't schedule an appointment. And for me, I like to see what's going on without them knowing that I'm coming. But there's times when we have to schedule an appointment because they might be working late, no one's home, or the kid who's now an adult is still in school. Usually I think they're up to like 23 or 24 years old, where they can stay in school. So they're in school and they're still learning, and then they come home and we do the interview.
So what do you have to, how do you clear that with the school itself?
Actually, we just go to the school. We go to the office, talk to the principal,
Okay.
and make sure that it's okay for the principal to let us talk to the student. We'll then pull the student out of class, or they'll give us a little small area to be able to talk to them.
So it's a private interview?
Yes, sir.
Okay.
Yes,
So
sir.
tell us when you're in a house, what are you looking for? I mean, what would be, what do you consider a good environment?
We're making sure that it's clean. We're looking for good, really escape routes for if there's a fire or anything like that. Making sure that there's no whole bunch of debris or a whole bunch of junk in the house where they can get out. We're looking at the structure of the home to make sure that it's livable.
Okay. So I noticed on some of your reports, you say that it's particularly in situations where there's hoarding, that it was actually a danger. Is that right?
Yes.
Yeah. Okay.
So we also ask them about if there's any POAs, which you have talked about. We ask them if they have a will. And then we also ask them if they have a therapist and or a case manager. And once we find out any of that information, we come back and we put it in our reports. So once we come back, we do the return of service to let you all know that the service has been conducted. And then we do our investigators report, which all the information that I just told you about, we put in there. And that's really about it.
Okay. All right. Thanks.
Yes.
Right. Any questions regarding the investigator? Or what happens? Okay, then I'd like to move on to, I did talk about the BCI, the background check. I did want to mention that that is something that has to be done. It's basically completed by like the sheriff's office. And it's very important that the background check be sent to the court directly by the agency that runs the report. And this is why it's good to try to get that out of the way early, because sometimes it takes quite a bit of time, several weeks at least, before that comes back to the court. And if we've set the hearing, then sometimes there's times where we have to have the hearing, but we can't grant the guardianship because we have never gotten the BCI report. So basically, as I said before, we're looking for situations if there's been issues of physical violence or crimes of physical violence. We're very interested to make sure that there's no such violence. We're also looking to make sure if there's an application to become guardian of the estate, there's no issues with crimes of theft that appear in that record. Most people are fine, but there are situations where we have to then inquire about those things. Again, the BCI is a report. The need for the report came out of that Rule 66. So I wanted to talk about what the court hearing is like. So we normally schedule the hearing for 1/2 hour. So we set a time. They usually run either in the morning from 9 o'clock through 11, or from 1:30 to 3:30, 1:30 to 3:30. So basically they're 1/2 hour. As Mr. Bailey said, if the ward has requested to come, the court will make accommodations for that if possible. Make sure that the person's there, or at least has a reason why they're not there. And so the typical guardian of the person in a state would start with the magistrate will come in the room. We will introduce ourselves. We will list the name of the case and also the case number. Then we would have everyone identify themselves. We would have the attorney identify themselves, the applicant identify themselves, the prospective ward, and so forth, with full name and address. So we have it in the record. And then usually we check the issue of what's called service. And that is that all the necessary parties, all the parties entitled to notice, in addition to the ward, were given notice of the hearing and the time correctly, either personally or by certified mail or FedEx return receipt requested, to make sure that all the parties had notice and an opportunity to come and contest the application or file a competing application, which often happens. Then we go through that. So we go through the service issue. We check how many people are, if there are any competing applications, and usually there are not. Then we swear people in. We would swear the applicant in. And normally I start off by asking people name and address and things like that. And then also why, in their own words, that they're seeking guardianship of their ward. And I let people have a chance to talk about what issues led them to decide to seek guardianship. And then we go through the various forms that I've already described. We will go through the application. We'll go through the statement of expert evaluation. And usually I talk with the people about what it said, and is that their understanding, and is that as far as they are concerned true and correct. And then we talk about we go through the investigate. So we go through the expert evaluation. We go through the investigator's report. Again, they've had an opportunity to see this. It's online, and they have a chance to explain anything they would want to explain to me. But basically, I go through that report, and they confirm the observations of Mr. Bailey or any of the other court investigators. And if they have anything they'd like to explain, they can do it then. If there is a guardianship of the estate, we go through the bond, the amount posted, the company that posted, and if they understand the nature of the bond and what it that the bond has to be twice the value of the personal property and the income of the prospective ward. And then we note whether the bond is sufficient. And then we go through the various documents that are already pre-signed. The first document is the guardian's oath. The second document is the fiduciary's acceptance. The third document is usually the obligation of the guardian to keep the court advised as to the address of both the guardian and the ward, because the court uses that and keeps that updated. And the guardian is the one that's responsible for keeping us updated with the correct address, so that if we have to communicate with them by mail or send out an order, it's going to go to the right address. So we ask them if that's correct, and they go through that, and that they've signed this promise that they'll keep the court advised as to where the ward is. We also, if it's guardian of the estate, we go through the necessity to file an inventory. Again, we go through the necessity of having the guardian file an application to expend funds before they expend them. And we talk about the need for an annual account, which is an accounting it starts with the opening amount of money, the expenditures, and the final amount of money. And then you have to show the bank statement that backs up that account. And we also talk to people about the mandatory training that is required now for all guardians. There is a one-time 6-hour fundamentals course that is available through the Ohio Supreme Court. It's, as it says, 6 hours of training. You get a certification. That certification then has to be submitted to the court within 1 year of the appointment of the guardian. There are also additional courses for additional years after the initial training. If there are situations where you can ask the court to waive any further training after the 6-hour fundamentals course, but we would prefer that you continue to keep your education training up. And that's decided on a case-by-case basis. We also at that time usually hand out an additional folder of information that's helpful, how to get the training online, how to contact the court. And we also include in that folder a form that you can fill out, the guardian can fill out, that we have a system here at the court that will notify attorneys and guardians of upcoming obligations. So if you give us your email, we would put that in the system. And for example, like a report was due, in May, we would send you out in April an email message saying that report, the annual report is due. And then you'd be advised that you have 30 days to get it in. So it gives you a little heads up as guardianship keeps going on year after year. There is a need for all guardians to file an annual report, which is basically a statement that tells the court what has occurred over the past year. You have to also file at that time an annual plan, which tells the court what's going to happen in the upcoming year, what things you're planning for the ward and what events and so on. And then with guardianships, you must submit an additional updated statement of expert evaluation every 2 years. So now that statement of expert evaluation, once you have the initial statement of expert evaluation with your filing, we ask that one more be done. And then after that, you can ask the court to waive any further statements of expert evaluation if it appears to the physician that there will be no change in the condition of the ward's mental status. So that's something you can file later, but we ask you to do the original one. We ask you to do one more, and then you can ask the court to waive any further statements of expert evaluation. And then at that time, the magistrate will normally tell the applicant that given the fact, if everything's in order, that the magistrate will prepare and is required to prepare a magistrate's decision and recommendation to Judge Brannon. And basically that sets out that the applicant made the application, that the ward is mentally incompetent, that there are no lesser restrictive alternatives to an actual guardianship, that the applicant is a suitable person to be appointed as the guardian of the person and or estate, that the proper bond has been filed, and that gets sent up to the magistrates will prepare that, send a copy up to the judge for his review, and the judge then has a chance to review the file again. If he accepts the magistrate's decision and recommendation, he will put on his own order finding that a guardianship is necessary and that the guardian is the applicant is an appropriate guardian and so forth, and will also sign the letters of guardianship. And that is the document that comes from the court with the court seal that allows or shows other people in the community that you have the authority to act as the guardian. That gets sent up to the clerk's office. If you have an attorney, it gets sent out to your attorney's office, all those documents. If you don't have an attorney, we would mail it to you directly. And I do want you to know that if you need additional letters of guardianship, you need just to call the court and we will send them out to you, as many as you need. So that's sort of the basics of the court hearing. And they usually last somewhere between 20 to 30 minutes. And in most cases where guardianships aren't contested and where it's pretty clear from the statement of expert evaluation, they don't tend to get continued or there's no problem, and the magistrate's decision goes on. The judge's order goes on the same day, and usually that's sent out to you, the letter of guardianship. So that's sort of the court hearing part. Any questions on that?
I don't see any questions listed just yet.
Okay, so one other area I wanted to touch on was sort of how we stay in touch, and that was the part about the reports and the plans. But there is another element to guardianship, and that is sometimes we receive what is referred to as a guardian's complaint, and this is Montgomery County form number 17.0F. The Supreme Court mandated that there had to be a way for people to make to put the court on notice of a possible problem with the guardianship. And what they mandated was that there be a complaint process. And so Montgomery County has followed that and basically has a complaint process. The complaint process consists of a person filing a guardianship complaint. And basically that is, you give information regarding the ward, you give information regarding the person who's making the complaint, your name and address, phone number, and places we can contact you. You give the guardian's information. You give information about the complaint? I mean, is the guardianship in effect? Has the probate court considered the matters you are concerned about? Have you complained to any other court or agency? And have you discussed your concerns with the guardian? And then on the second page, you can set out in detail what you think is not happening or should be happening and is not happening, or whatever complaint you would have. And this can be filed by anyone. This can be filed by a worker at the, if the person's in a nursing home. This can be filed by brothers and sisters. This can be filed by children on behalf of their parent who may be a ward. And the court's mandated to review this and deal with it. So, Mr. Bailey, can you talk about, have you had to investigate these?
Yes.
And tell me what your process is.
I've had a few of them since I've been here. Usually the person that they're complaining on, or the guardian that they're complaining on, we usually send them out a letter and let them know that there is a complaint. Whatever the complaint is, we go out to do the investigation, whether it be, I've had some where the person said that the person was being left alone every day. So we go out, and what I do is just kind of go out on various days to see if that person is home, if they're left alone, or if they're there. With my experience right now, every time I've gone out, there's always been someone there. But I also check with neighbors and talk to neighbors and see what they say, and I put that in the investigation as well. Sometimes it's a ward that is complaining maybe to the facility that they are in, and someone from the facility is acting as someone for them to then do the complaint. So we'll go out to the facility and we'll check out whatever that complaint may be. Again, like you said, anyone can do this. So sometimes it might even be like sometimes if a mother might have guardianship and the father does not have guardianship and they are separated, the father might have a complaint, or the mother might have a complaint as to how she's being treated and taken care of by the facility. So we go out and we monitor that.
Okay, and usually based on an investigator's report, the court has the option to always set the matter for hearing. And we have set these for hearing to have the guardian either explain what's happening, or to have the person who's making the complaint come, and we would ask the guardian to attend and explain what's happening. Normally they get resolved, but I think it's a good thing because it provides people with a way to make sure that the ward is not endangered, make sure that the ward is getting the care that they need. And if something is amiss, I think the court wants to know that in order to call the guardian to account for what's happening. So it is a process. We see them not that often, but not often, but when they do come, we take them very seriously because it can be something very serious. So that's how we handle that. And if necessary, actually the judge would hear it.
Yeah, and for it to be resolved also, when we get these, we make sure that we talk to the magistrate about it before it to be resolved. We also, at the end, we let them know what the result is, the guardian and the ward.
Right. Yeah, we send out our decision, and and these are placed on the docket. So it's part of the guardianship record. So if we see another one coming along, then it makes us all the more hyper vigilant to try to see if the ward is in a safe place, if there really is a serious issue that has to be addressed. And that would include even the removal of the guardian if necessary. So the court takes those very seriously. So thank you.
Yes.
Any questions?
I don't see anything at this point yet.
Okay. Patty, I don't really have too much more. Is there anything else you would have any questions about?
We have, if anybody has any questions, I'm going to go ahead and stop the recording. So that you can ask if you don't want to type it in the chat box. Maybe something that, you know, maybe if you are going through like looking at the guardianship process and there's a part of it that makes you stumble or you're unsure about, now's the time to ask. Even though I know they're representing the Montgomery County Probate Court, I know there is like a baseline for probate courts, and they can maybe help you with maybe if there's some other, you know, hurdle or some sort of decision you're trying to figure out where the first step is. So 1 second, why I'm going to go ahead and stop the recording so we can open it up for discussion for those who would rather, who would like to just, you know, speak without, and you can raise your hand. It's fine. I did put some links as you were speaking on in the chat box regarding the Montgomery County Probate Court, regarding their website link. I added Gail Miller's information and then some of the forms as well. So 1 second, let me stop the recording and we will open it up for discussions.